your view, is it like really, do you see this as one of those judgments where Supreme three judges bench was forced to use its 142 power? Was it in your view, a case where the court needed to ignore that very important principle of finality of the awards and set aside the award? So,
on principle, I would say it is wrong. For this reason, that this matter is not coming up in a civil litigation or any other commercial litigation, except it is coming out of arbitration. And Arbitration Act intends to, by Section 5, say that judges should keep off from this, unless otherwise provided before in the Act. Now, the Act gives you very limited jurisdiction. And in any case, what is this curative petition? Curative petition was decided long ago when I was still in the Supreme Court. And the Supreme Court of 5 judges, 3 did not go into this, but another 2 added it and said, rarest of rarest cases means what? They have said, where there is violation of natural justice, or there is a discovered bias of the judge, or there is an abuse of the process of law. I have sat in the Supreme Court, curative petitions have been dismissed on the ground. These kinds of things are not present in this. Now, can I say honestly that in the award that was made, there was violation of natural justice, there was bias of the judge, or that it was an abuse of the process of law? So how do you interfere? Shocking the conscience of the court. Way back in England, when equity jurisdiction was started, the chancellor used to say, it shocks me, and therefore this term of chancellor's foot, that the equity varies with the foot of the chancellor, came about. And one of the judges in the equity chancellors, when he retired, caustically remarked about. Now this is exactly the chancellor's foot, instead of it will be the judge's foot, that's all. There is no chancellor here, because we also exercise equity jurisdiction. See, the question is this. There is no hard and fast principle that one person's view is always right. Grant you. Therefore, the law has said there should be another process of reviewing that person's judgment. And luckily, the law in arbitration is not appellate power. When you pass an order on 34, you are not sitting in appeal over the award. When you pass an order under Section 37 in an appeal, you are not sitting in appeal over the award, but you are sitting in appeal over the process over the 34 judge has done. And 136 is the most abused provision in this country. And 136 is supposed to be an extraordinary situation. Very well, Supreme Court interferes with. The curative petition is supposed to be like a rarest of rarest capital punishment cases, murder appeals. So what is it? These 3 principles are there. Now, if anybody can show me any of these 3 principles arising out of the award, and in any case, look at the way the judgment says. Oh, the arbitrator did not consider X evidence, it did not consider this certificate of appeal, did not consider the evidence. That is not the jurisdiction of the court at all. And if it is not the jurisdiction of the court, the Supreme Court has no business to interfere accordingly. Not even under 136, not even under much less under curative. The only problem that is going to rise is when special leave petitions were freely admitted. I was just talking to you earlier. Earlier, there used to be a certificate process, like in Privy Council cases in India also. Under the High Court certified that it was a fit case for appeal to Supreme Court because of an interpretation of Constitution, or because of some general public law was to be interpreted. And that certificate had to be issued by the division bench of the High Court. And then only they would admit the appeal, and in rarest of rare cases, maybe 1 in 100, they would admit an SLP. SLP was supposed to be itself an extraordinary remedy. Now we have totally emasculated the Constitution. 132, 134, 134A is all thrown into the Arabian Sea. And whatever happens in the High Court, you run to the Supreme Court. Kya ho gaya? Supreme Court tak dodo. This is. Well, I'm sorry to say this. I've been a judge of the Supreme Court and I have expressed this sitting in the Supreme Court. I'm expressing outside the Supreme Court also. And particularly, this curative thing was another way of saying I want to grant relief in this. Very well, even at least they had an objective manner of doing it. Violation of natural justice, bias of judge, abuse the process of law. Over and about, what is it? Shocking the conscience. They have added a 4th ground. I have not understood. You can't say it's perverse. It's perfectly tangible, if it's perfectly feasible for the arbitrator to look at the evidence and say, I am giving more importance to X than to Y. And that is why Section 34 doesn't give such an appellate power at all. What the Supreme Court has done is exercise appellate powers over the award. And that, according to me, is wholly erroneous. And if this happens, as it is, we keep on saying that we want to make India a hub of international arbitration. And in the days will be, the chance will be very less. And in foreign jurisdictions, the rule appears to be that what should be looked at is not the actual award, terms of the award, the decision of the award, but the process by which the award was made. If it is erroneous, interfere. Otherwise, don't. Interfere and say, go back and do it again. No, it's not an appellate power. Appellate power is never used like this. You don't scrutinize the evidence and say, this is good, this is bad, this is indifferent. I'm sorry. These are my views. And it's for the other panelists to take it and deal with these views.
I would want to pose the same question to Professor Paul, but before that, I just want to add one doubt of mine in general, also as a professor, which we all share, that when we are talking about like the ground of patent illegality, and also when we are looking into most of the cases, it turns out that when a supervisory court is scrutinizing an award on the ground of patent illegality, they end up getting into the merits of the case. So that becomes more or less inevitable. That's what we've seen happening.
Patent illegality is a situation where you look at the award and say, this rule of law has not been followed. Now, if you have to scrutinize it, it is not, obviously it is not patent, it becomes latent, no? You don't need an argumentation. It's ex facie seen. That should be the attitude. A patent does not mean you are going to scrutinize the evidence, say, usne ye padha nahi, he gave more importance to X witness as against Y witness. Why did he not consider Z witness? That may be already in a criminal trial. This is an arbitration award where the parties, they exercising their party autonomy, have chosen this person or these persons to be my judges. Once you have done that, you have to stick with what they have passed, right or wrong. Only provision is 34 and 35. Now, if you have on top of it High Court, if you have on top of it Supreme Court, then why not appeal to God himself, saying that these judges are wrong?
Right. Professor Paul, I think I would want to have your views on this.
Yes.
So first of all, I would like to thank all the panelists, and it's a privilege to be sharing the panel with Justice, none other than Justice Srikrishna, whose contribution in arbitration has been immense, and we all have learned from you, sir, a lot in the field of arbitration. So I'm very happy to be on this panel. So, all of us agree with what sir is saying, but I want to put it in a different way. If you look into the scope of jurisdiction which the Supreme Court has under 142, then we will not win the argument, because that gives unlimited power to the Supreme Court to do complete justice. But at the same time, the Supreme Court is also, because if you read Article 137, it also says subject to the provisions of any law for the time being in force. So in that light, the Supreme Court, I know, has written this judgment. In my view, the primary concern of the Supreme Court was the financial implication of the judgment on a public-private entity. And even if you see that, then also initially the liability was 2,900 crores only, and it exacerbated to 8,000 crore because of the appeals and multiple appeals which have been filed against the arbitral award. So one thing which has to be kept in civil cases or in fundamental right cases, exercise of the jurisdiction by the Supreme Court is a welcome step. But when you see arbitration matter, one thing which is very important to be kept in mind is parties have entered into an arbitration agreement, and they have willingly let go of certain rights which they have under civil administration of justice, which is right to file appeal and right to go to Supreme Court under multiple appeals processes. So these are some, and also if you see our Arbitration Act, we have gone a step ahead of the English Arbitration Act, where we have not provided a ground of under Section 34 of the substantive review of the arbitral award. So we have deliberately, we could have done that, but we have not done it. So which means there are very limited grounds which are available for setting aside an arbitral award. and there are very limited number of appeals which are available. Now, in my opinion, there should not be a single bench judge High Court appeal which should be there. It should be directly, it should go to the division bench of the High Court to just cut down on the number of appeals which may be available to parties. But at the same time, even if we see miscarriage of justice and patent illegality, which is being discussed in the judgment, that also, even if you consider that at the stage of enforcement under the Act, even the enforcing court will have jurisdiction to look into the patent illegality. So, but that is something related to error apparent on the face of the record. So that is something which should be visible on the face of the record and not by the reappreciation of the evidence or going into the merits of the award by the arbitral tribunal. Another important factor which we have to keep in mind is the spirit of arbitration, Article 5, Section 5, which Justice Krishna just mentioned, and the requirement to have technical arbitrators in case of technical disputes. So we had an arbitral tribunal which composed of people who were expert in that area of law, and we cannot expect them to be to the same kind of precision which a lawyer or a judge would have in dealing with cases. So speed, finality, all of these are essential features of arbitration law, which are also something which needs to be protected. And especially it is a commercial dispute, and in commercial dispute, there is a requirement of exercising judicial restraint. The court would have looked into the year which have been spent in this litigation and number of courts which have applied their mind in it. So I feel in regular civil cases, fundamental right cases, this kind of decision of Supreme Court would have been a welcome step. But when we talk about arbitration matter, this is, I think, not just this ground, but any other ground should not have been available for curative petition stage. Thank you.
Okay, thank you, ma'am. Yeah, okay, so I think we all kind of tend to agree, and everyone would agree on that. As I said, when we started conceiving this, we were just thinking that everyone agrees on this or on the same page, that exercise of curative petition or the curative jurisdiction in a commercial dispute, and especially that too for arbitral award, is like not acceptable, should not have been
if you wanted me to argue the contrary, I would have argued successfully, don't worry.
Okay.
But I have to give you my honest opinion.
Right. Yeah, maybe, okay, we will hear your views on the opposite side also. But there's one thing which came to my mind when I was reading, and also it gets reinforced. Like, of course, we all are against this curative petition and the judgment that has happened. But to my mind, it is also problematic. And as I said, that we are admitting all SLPs. So that in Section 37 appeal, the Delhi High Court Division Bench had set aside the award. And then it got reversed by Supreme Court in SLP. And then in SLP also, Supreme Court more or less performed the same function of reappreciating the evidence. So High Court in appellate power set aside the award, and then Supreme Court then again acted as the appellate court. So can we not say that apart from the curative petition, the previous stage, the former stage, where the SLP was used to set aside appeal or the division bench judgment of the Delhi High Court, doesn't the problem lie there? So probably
therefore, no, this is wrong. You can't sit in judgment over a coordinate bench. Even 5 judges cannot say the judge is wrong.
Right.
So there's a curative petition. There is no intra-court appeal in Supreme Court.
In Supreme Court.
Otherwise, there will be RJT, there is so much confusion, it would have been impossible to handle.
Right. So I can probably request Gauhar to have his views on like this whole process that went through. And then Karthik and Priyanka, I'll come to you with a similar question. Yeah.
So I am also a critique, of course, of the jurisdiction that has been exercised by the Honorable Supreme Court. But on the other hand, I want to also argue on the other side as well. If you see, Justice Srikrishna rightly pointed out that it was not, the coordinate bench was not sitting over judgment on it. And Dr. Nidhi, you very aptly pointed out that the finality was achieved at the stage of division bench under Section 37, where it was held that the award was patently illegal. If you actually go to paragraph 71 of the judgment of the curative petition, it actually questions only the exercise of 136. Rather, we are all, of course, we are all geared up to act against the judgment and say that the curative should not have been maintainable and Supreme Court should not have gone into the award. I would see it a little differently from a positive perspective, that the questioning that was done by the Supreme Court was only to the exercise of power of 136, rather affirming the finality of the award at the stage of 37 is what my take would be on a positive side. Also, if you see on another positive streak that I would provide is that we make mistakes. Everyone makes mistakes, right? And then Global 1 was everybody later on said that it was a mistake. We learned from the mistake and later on we corrected it. Maybe it's just a guiding side. I will only say that it is, of course, a problematic situation that we see, but reappreciation of something in a curative jurisdiction may not be the stretch that we are trying to.
You're out. Again, muted.
It was only a question of exercise of 136 and nothing else.
No, but our curative petition has objective standards already laid down by the 5-judge bench. And I just repeated it earlier. 3 circumstances. Right. Violation of natural justice. They have talked a lot of general principles, shocking with the conscience of the judge and all that. Finally, at the end, they say, these are the circumstances which should be exercised. 1 is violation of natural justice. 2nd is bias of the judge. 3rd is abuse of the process of law. Which one applied? Otherwise, you're sitting in appeal over your coordinate bench. How do you do that? Under which
absolutely.
law of the Constitution, under which provision of the Constitution can find a just sit in appeal over the division bench? There is no.
So, but correct, absolutely, sir. I completely, just for the record, I am with you, sir, on this point, and I'm not arguing against it. I'm just trying to take a positive side of how
I could have
things.
taken a positive side even stronger, but I said, let us honestly talk about it.
Yes. No, I am talking very honestly. I am also a critique of the judgment, but also seeing the positive side. If you see the last line of judgment, I don't know whether the award was properly seen or not, but the last line of the judgment actually says the process of arbitration has been perverted by the arbitral tribunal to provide an undeserved windfall to DAMEPL. This is a very big.
How do you decide that unless you scrutinize the evidence, they chop it into bits and pieces? Is that the job of the judge? And in a curative petition, I can't even think of it.
Sir, maybe. And
7 judges sitting down very solemnly and giving these guidance.
Absolutely,
that is all that we have always applied. Suddenly you get up and say, arbitral petition is because the judge has become perverse. Perversity is not one of the tests.
Sir, with absolute acceptance to what you're saying, we are seeing some awards these days which are actually absolutely perverted, and they are being performed and they are being executed in enforcement.
See, the point let me just. This is exactly the point I want to make. All this happens when the government is a party. When the government steps into the arena of commercial disputes, it has to be treated like a commercial party. Commercial party A and B fight. One person loses, another person succeeds. Arbitration is the method by which they do it instead of litigation carrying on for 25 years. Now, if you are chosen, they say, no, if your maid is bad, you must lie in it. Then now don't cry and say the bud hurts you. This is precisely what is being done. Every time the government hurts, judges say, oh, kya ho gaya, perverse. Now, series of judgments I have seen this happen. He is not an exception. This is the point why I am saying, don't even say that we want to make it a hub for international arbitration, because nobody is going to come to you if you are going to do this. In which other country has this kind of a thing done? Show me. You people have a lot of experience.
No other jurisdiction gives judicial processes the power to interpret an award.
In fact, I am opposed to even 136 being accessed.
But sir, we have to also see it just as a matter of argument. We also have to see it from an enforcement perspective. We also have to see what grounds have the private side.
Ultimately, what have you said? I think this is injustice. I am going to interfere. That is all that is some substance of this long judgment. Otherwise, there is nothing else in that which can be fit into the legal matrix. Now, so what was wrong in the Chancellor's foot theory in London, in UK? In England, the equity judge, the Chancellor, his judgment varied according to the length of his foot. We are doing it same here. That's all. I don't like this because it is something wrong. I think it is perverse. I said, in what? In the curative petition. Very well.
No, so
I can understand if it is a
exactly.
question of a person being put to capital punishment, at least there is a reason for somehow or the other you may just save the life of the man. No, this
No,
is
sir.
the
From that analogy, let me just put it a little differently. DMRC is a government organization. The quantums we have seen. I don't want to discuss quantums of the award. Maybe the quantum puts the government or the exchequer back to a situation where it can actually be so perverse that it affects a general population of the country as well. Now, just give me 1 minute. I want to explain you from another perspective. So you must have seen that Vishwas Se Vishwas scheme that the government came out with recently, where all the awards that have been passed again any PSU or any government has to be paid to a particular extent without any question being asked. Let us take that example. Suppose I have a 100 crore award against a PSU, and I apply that Vishwas Se Vishwas scheme, and the award is actually perverse and actually patently illegal. I have to shell out 75 crores without even that award being questioned. Are we saying?
Please, what does Section 5 of the Arbitration Act say? In interminable litigation, it says court shall not interfere except as provided in the Act. Act provides you two remedies, Section 34, and if the Section 34 judge is wrong, Section 37. Over and above that, SLB, over and above curative petition, if I had God himself, he would say, all this is wrong, I'm going to interfere. Where is the limit? Whole purpose of the Arbitration Act is discourage litigation, discourage these people going after appeal processes, isn't it? Unless you are disagreeing with me. Section 5 is something that says now, put an end to all litigation unless it is necessary under this Act.
Absolutely.
Yes. Yo, sorry.
Yes, Nidhi, you want to?
I
Yeah,
realize I'm
I
not getting in the
want to hear from now
fine.
Karthik and Priyanka on the same issues. Like
Very
my
good.
idea was like when the very SLP itself was problematic, and it was like
Yeah, correct.
once
You asked
finality
me,
was
SLP itself has been abused. I will talk about it in another occasion. Today I'm not talking about, I'm talking about the curative petition.
right. Yeah. So Karthik and Priyanka.
Sure,
you
Nidhi,
had-
I'm happy to chime in. I mean, I've had the benefit of listening to Justice Srikrishna here, and I echo no words which are different from what he is. And I don't think I'm here to take any contrary stance to what I've already taken, which has been published in the press. But I genuinely think that this decision is a huge setback in a lot of ways.
Karthik,
One,
you are from Singapore. No, I'll tell you an experience I had in Singapore. This is what I say, how you should interfere or not interfere. We had a situation where a lawyer did not turn up on a particular day, which was fixed almost 1 year ago. And then final arguments, when we were about to raise, the man comes in and says, give me an adjournment. I was busy in some other matter or that. The tribunal said nothing doing. We proceeded with the award as ex parte or without his arguments. That was challenged. What did the Singapore High Court do? They asked him two questions. Were you given notice? Were you present at the time? Sorry, we will not interfere. That should be the attitude of the judge. That is
and I completely agree.
That is why Singapore is a high point for all arbitration.
Yeah, and I completely agree, sir. I mean, I don't disagree at all. Frankly, if anyone asks me if there is a choice of a seat, I have never recommended an India seat over a Singapore or a London seat. And I never will.
And pray, why do you say that?
Sorry?
Why do you say that?
Because of finality. Because
Absolutely.
people can
That's the whole
determine
point.
the risk. The people can determine the risk, what an award will be
Yes.
subjected to after getting passed. Look at what has happened here. The arbitration was filed in 2012. It was commenced in 2012. You had more than 12 years of proceedings, 5 levels of proceedings. And forget about those are arbitration and appeal and set aside whatever. They were another set of proceedings. Execution proceedings were going on in Delhi High Court. Petitioner had gotten a deposit order. Deposit had been made. Imagine what kind of a reflection it is. You have the entire course of arbitration, and here you are, the topmost court of the country, saying quash the execution proceedings. If someone goes to the judgment, para 69, they have quashed the execution proceedings. It is absolutely against the commercial wisdom.
Unheard of, if I can use a strong word, it is absolutely unheard of. Yes,
Completely.
Unless you want to make a landmark judgment, which only means that you are marking the land. There's nothing else.
Yeah. And so just going back to your initial remarks, I mean, Rupa Ashok Hurra, from where it all started.
Yeah,
look at the facts. It was not a commercial dispute. How can you apply curative decision curative jurisdiction Article 142 to a commercial dispute. 142 for doing complete justice has been used in Rupa Ashoka, right? Has been used in Vineet Narayan. It has been used in MC Mehta. Look at what the public good is at large. A commercial enterprise, which is half owned by Delhi, half owned by Union of India, receives funding from Japan, it gets a setback in arbitration, and you are applying 142 for that purposes. It makes absolutely no sense. There were two original grounds of 142 when it all came into picture. One was violation of natural justice, and the second is that a judge failed to, there was an apparent bias. A judge failed to show what connection he has, etc. Where is all of that applicable here in this present case? It has been heard by competent people chosen by parties. There is absolutely no question of the Supreme Court interfering in the commercial wisdom of the parties. Imagine the message it has gone. How do you defend Indian arbitration?
Correct.
You can have an arbitration bar of India, or you can have as many amendments. But
Yes.
you cannot defend arbitration in India if you have these decisions.
I know the next time I go on an international arbitration, I will have to answer these questions.
Okay.
Sir, I have to answer it every day sitting in Singapore.
So while Nidhi, I just want to add to what
Yes, please,
Karthikeya
yeah.
pointed out. While Karthikeya has said that he would never recommend to a client that India should be the seat, I want to ask a question that he sits out of Singapore. How many enforcements are being filed in Singapore? Answer is no, none. Why? Because in the sphere of enforcement, Singapore is bad. So you can't sit somewhere outside and then
I'm
question.
sorry, Gohar, why is Singapore bad?
No, you have you ever seen enough enforcement being done in Singapore, enough assets being there in Singapore just by outsourcing arbitration outside of India and getting an award and then questioning what Supreme Court does? I don't think that matches properly, because enforcement, Singapore is not the hub for enforcement. You also know that.
I
We
mean,
all know
that is because assets are not there, Gohar, not because
Yeah,
jurisprudence
but
of the
just
law
to-
doesn't support.
And not
Very
because
good. But just to say that this sets back India's
all right.
scene on the international
Yes.
scenario, and also say that arbitration bar, etc. I don't think that's fair. I actually am a critic of the judgment, but rather I'm actually getting towards the other side by hearing all this, because how much criticism can you do? All right, Supreme Court did it in one
Wrong, it
case,
is
and
wrong. Why don't we
somebody-
accept? Why don't we accept it? Supreme Court is wrong. That's an end to the matter.
No, it's not wrong. According to me, it's not wrong.
Very well.
Now
Please, all right, very well.
after hearing Karthikeya, I've
Forget
understood.
Forget
that the-
Karthikeya's remarks. We are talking of Rupa Ahura's case. Which one of them applies? Has the Supreme Court found any one
There
of
has
them?
been miscarriage. The Supreme Court, in its own
They looked
wisdom,
at,
sir,
but what did they do?
has come to a finding there is miscarriage of justice. For whatever it's worth,
Very good.
whether it
Now,
is
if-
worth the paper it's written on,
Very well.
but
Under
a
which-
decision has been made. We have to accept it. Rather, as I said, we will correct it in the coming course of time.
hopefully so.
But today saying that this puts India back and one has to answer internationally, I don't know how does that match. You should stand up and say, okay, India has done this, we will progress further. So I think saying all these things is a little stretch to what we are discussing here.
I think we could hear Priyanka also on that. Priyanka, like what kind of a commentary is this on the dispute resolution scenario in India? Or I also
Sure.
like not like ease of doing business motto, right? So all that we seem to be. So what would be your views on that?
Sure, but before I get in, I'll just provide my 2 cents. While I largely agree with the panel here, curative is really an extraordinary inherent jurisdiction by the Supreme Court of India. You cannot really exempt any national legislation that includes the arbitration legislation and tell the Supreme Court that no, you must not exercise curative just because the matter emanates from an arbitral dispute. I certainly agree with all my panelists that this may not have been a fit case to entertain a factual exercise and determination by way of a curative jurisdiction. But let us see what happened a few months ago. The issue of stamp duty and arbitration agreement, that issue required a course correction of law of the country. And the Supreme Court stepped in by way of a curative jurisdiction and set the course right, of course, in support of jurisdiction. Unfortunately, we have this jurisdiction now, this decision now of the Supreme Court, where a curative was exercised, not in relation to interpreting the law, not in relation to creating the law, but curative here was exercised to consider issues of evidence. Curative was exercised to consider whether facts were correctly applied by a tribunal. I think that, for me, impinges on the essential hallmark of arbitration. And it also impacts your doctrine of finality. A Supreme Court judgment may be fallible, but it has to be final. And to your earlier question, Nidhi, whether the SLP restoring the arbitration award, did it impact the doctrine of finality? I have a different view there. I think Section 34 of the Arbitration Act says that parties can approach the Supreme Court. Now, the Supreme Court can be approached by way of a special leave to petition. So, of course, it is not a right to appeal. It is only when the Supreme Court is satisfied that the issue of law or the present judgment before it is something that warrants an interference, will the Supreme Court admit the SLP and hear it? Having said that, in this particular matter, SLP did get admitted. What did the Supreme Court do? It restored the arbitration award. By doing so, I think that was one of the many pro-arbitration decisions that have come out from the Supreme Court in the past. It recognized that a Section 34 judge has to have a hands-off approach. It recognized that the tribunal really is a master assessor of the merits. It will only interfere when the arbitration award is either perverse or patently illegal. Like Justice Srikrishna said, a judge may not agree with the decision of the arbitration award. But if that is a possible alternate view, if that view has reasons, and if natural justice has been met in the arbitral proceedings, there is no reason that warrants interference by a Section 34 judge. Again, taking to what Justice Srikrishna said, Section 34 is not an appeal. Section 37 is certainly not an appeal. An SLP is a leave to review whether the law was correctly applied by the Supreme Court. Why then are we extending a curative to review the merits and ascertain if a certificate was binding between the parties or not?
Right. Okay. So yeah, we all, as I said, we all tend to agree that the exercise of curative jurisdiction was not right, maybe contextually. So probably, as Justice Srikrishna also said, that since government was one of the parties. So before I move on, Professor Paul, I would want to ask you also, like Karthikeya said, that he would never advise a person to have India as a seat of arbitration, because of course, for obvious reasons, not only this judgment, for many other reasons too. So do you perceive this judgment as something which will have an impact of ease of doing business motto of the government, or generally will impact the dispute resolution scenario in India, as India being an arbitration friendly jurisdiction?
Didi, can I jump in for a moment?
Yes, sir, please. Yes, sir.
The point is this: forget curative petition, forget everything. Take a simple situation. Start your videos. My video is off on. Okay, what? All right. A civil litigation ends in a decree. There is an appeal. There is a second appeal. We'll assume there is a SLP also. And we'll assume there is a curative petition also. And therefore, look at what happens. Normally, if all this process is not done, and the man says, I will accept the award has to be executed. And execution is the biggest problem in this country. I don't know how many of you have really done execution work, sitting as judge. I've done it in the Bombay High Court and in Kerala. Execution is the worst nightmare of a litigant who succeeds in the court. And an award is equal to a decree of the court. Therefore, you don't have any choice. So nobody does anything except execute it. And that execution is the biggest process. You will see that the execution courts are the ones who are the most overlaid with difficulties. And after having succeeded in all this, execution is quashed, finished. So the man has to, I don't know what's going to happen. That means all his chances are zero.
Right. Also, sir, but if we read the division bench judgment of the Delhi High Court, there the award was partially set aside in the Section 37 stage, and the court said that we would want to modify the award, and since we don't have power to modify the award, we are just
Exactly.
setting it aside. So that also like
Anyway.
so right. Okay. Professor Paul, I wanted to come to you with that question. With my earlier question.
Modification of award again is not a power with the courts.
Yes, so
and
that's what
Arbitration Act.
court did.
Remission is there, but I don't know whether any court is exercising the power of remission so as to give honor to the arbitral tribunal, which is actually the master of the facts in the case. So in respect to the question that you asked, Nidhi, I would say that because of this judgment, people will not come to India and have India as a seat of arbitration. But it is not just, this is not the one case which is the reason for it probably, because if you see the International Arbitration Survey conducted by White and Case and Queen Mary, there are some important factors which are there, which people keep in mind while selecting the seat of arbitration. One of it is greater support of for arbitration by local courts. And another obviously is the track record of enforcing agreement and arbitral awards. And similarly, for the ease of doing business in any country, the dispute resolution system of the country is a very relevant factor. And now if you see, even after the 2015 amendment, recently, the law for arbitration has been constantly in flux. Within 1 year, the decisions are overturned by Supreme Court. And there is a problem of certainty of law, which is also, again, very important for any country to thrive in business, which is also a very important factor, that investors should come to India and invest in India. And the dream, as sir is mentioning, of India to become a seat of arbitration, hub of arbitration, has to always be kept in mind. So it's not just this one decision which may have some impact in this area, but it is I think I will say there is a requirement of a change in at all the stratas. Firstly, the parties who are arbitrating the dispute, they should be keeping this in mind, that as to what they want to achieve in arbitration. Otherwise, they should not enter into an arbitration agreement if they still want to exercise all the options which are available under the civil administration of justice. So they have always the option of going to the court for all the disputes that they may have. And other is the courts, the courts, how they are interpreting the arbitration agreement and how they are deciding the cases, as somebody is talking of modification of arbitral award. And in one judgment, even the minority judgment was decided to be the main judgment. So all these kind of the decisions which are being rendered by High Court and Supreme Court, High Courts and Supreme Court, they may be fine if we are talking of regular civil cases, but they are not in line with the spirit of arbitration. Again, I'm saying that. And it is a specialized kind of dispute resolution process. Parties can also opt for the commercial courts processes, which are now also available. So choosing arbitration, also parties should keep in mind why they're choosing and what are they going to be getting after choosing arbitration as the method of dispute resolution system. And courts have to keep in mind the ethos of arbitration while deciding the cases, upholding or setting aside the arbitral award, and the limit of the jurisdiction which they have. So this is, I think, is my view. Maybe I'll chip in later.
Okay, great. Thank you, ma'am. Now, I want to just move slightly a bit forward. We all agree, as I'm consistently, we are saying that this curative petition shouldn't have been done. What court has done is like not acceptable, not also falling under the rarest of the rare, where it should have been done. Now, considering that this is what the situation there is in India, and it's like we say that the awards don't get finality. So a question that was arising in my mind was, does this judgment, can we say, does it carry any kind of a lesson for arbitrators or the practitioners for during the arbitral proceedings, to be able to keep in mind, especially when they are dealing with a contract which involves a PPP model and which involves government. So because government contracts, as sir also said very rightly, that had it not been the government, probably this situation would have been different. So do we consider government contracts as a separate category?
In other words, you want to make it undeclared arbitration to the Arbitration Act, that if government is the party, okay, you're in the hands of the judge.
So, Gaur, I would want to know from you first that do you think that the government contracts have to be treated as a separate category and this PPP model, which invariably involves a foreign party and, of course, infrastructure and big contracts?
You see, it naturally comes from the fact that government is the biggest litigant in the country. Like most of the arbitrations, or rather all of the arbitrations that are done in the country are against or for or against the government. So it naturally becomes a natural choice that yes, if government is involved, there has to, if adjudication has been done in this manner, you know what happens. But if you just go back to what Priyanka's example was for NN Global stamping, government was not a party there, but there was some adjudication happening even there. So we can't create a class just because somebody is in majority, or the litigation against somebody is in majority. I don't think there's a class divide or anything. But yes, how it pans out, or how it appears from outside of India, or maybe outside from a person who's not into the system of government litigation, etc., is that yes, it is being created as a separate class. And if government is a party, whether a special consideration may be given or a special due regard has to be given. I think it appears only optically, but in practice, I don't think there is a separate class.
Yeah. But at the stage of enforcement, so like for example, in this judgment, this says it shocks the conscience. It's perverse because, as you also said, that it might affect the larger population. So I think whenever the government is a party or a PSU is a party, this always will have as these kind of awards are always going to have an implication on the larger population or the economy of the country, or whatever we say. So don't you think that it is always expected, at least at this enforcement stage, that when it involves a government, it has to be treated differently?
This is most unfair. First
Yes.
of all, the government doesn't have the resources to do this kind of high cost, high ticket projects. So they invite people and say, please come and do this, the PPP model and all that model that have been developed, saying that I don't have enough money. Otherwise, the government should have done it. What do they do in Russia? What do they do in China? They don't ask people to come and participate in that. They don't invite others to come and do it. Or if they do it, they tell them point blank that you are doing it like what I want to do, you'll have to do. Now we say we are not doing that. We are democratic. We follow the arbitration law which has been passed by parliament. Now just follow the law. That's all. Don't interpret the... Otherwise, you see, what happens is, if the government is a party, their interpretation will be different. If Nidhi is a party, the interpretation is different. How can I do that? You can't do it in a civil litigation, can you?
To add to
Unfortunately,
what sir is saying, I think even in civil litigation, Supreme Court only has said this government cannot be treated as a separate category
exactly.
to have
Exactly.
separate kind of incentives or some kind of protections.
Yeah. So
Although talking of adjournments, government has always got the largest number of adjournments. With
True,
this in
that's
mind
true.
that because of the inefficiency of some lawyer, the government should not lose.
Right. Okay. Now, Karthika,
Anyway,
since
that's-
you have to, Karthika has to leave. He's just like probably has a commitment. So, Karthika, as a practitioner, as an arbitrator, do you think that your approach would be different when you are either like when you're presenting before an arbitral tribunal, when you are dealing with a contract which involves Indian government or a PPP model? And so would you approach it differently, or?
I think I would not approach the merits of the case any differently. I think I will do what I need to do in order to present the case on behalf of my client who is up against the government. But what I would do is prepare my client to the eventuality that the government will leave no stone unturned in terms of raising appeals, set aside, whatever, until they have exhausted all possible measures, which again ties in with the earlier point that we were leading to, that there is a lack of finality which the system is propagating, and users take advantage of it. It's not only government, even private parties take advantage of it, but government necessarily so, and more so than the private parties, is willing to go the last mile. Two reasons. One is that they have the resources to. Second is that they have some internal issues that they want to, they want to basically tell their seniors, people who are taking calls on these files, that listen, we have exhausted all possible avenues, and this is the maximum that we could have done. As a result of which, with that sort of an attitude, which is not an attitude of resolving the dispute and trying to get on with things and get on with new projects and, dedicate your resources there, it leads to a situation in which you're up against a counterparty that can, really exhaust you, really tire you. So you have to be prepared, and you have to be prepared to spend a lot to go until the last mile.
Yeah, okay. So Priyanka, if I ask you that the same thing, that do you think that you will have to deal differently with your clients who want to deal in because infrastructure contracts, big contracts, as I said, big ticket contracts, government is going to be a party.
Of course, I think government is an important player in any infrastructure contract. And of course, the infrastructure industry is going to be the third largest in the world by next year. Arbitration is here to stay. And of course, you cannot ignore arbitration in India, as a comment to both my panel speakers on this aspect. But see, having said that, the problem is not really the arbitration system. The problem is the approach to the dispute. The problem is the approach to the arbitration and arbitration-related litigation. When you talk about ease of doing business in India, we're talking about ease of an effective resolution of a dispute. And we're all talking about how it is paramount and important to have a national policy of litigation in India. I think as a government, it must also have a policy and ensure that it is a responsible litigant in India. Most of the pendency of cases in India, I think there are around 11 million pending today in civil and commercial cases. Most of those litigations will involve the government of India. And that can be corrected, that can be reduced. If the government takes an assessment, is this a matter that warrants an appeal? Is this a matter that can get into arbitration? And is this a matter where I can say, let us stop fighting the matter and let us resolve the project?
Yeah, but in principle, since it's always public money involved, so do we really see government acting as a commercial party? So as long as government continues to be one of the important contracting parties, so do you see that really government not exhausting all the appeals or trying any government department or any PSU not trying its best not to pay the award and to keep deferring it? Like, do we see any solution out of, or do you see any way out of the solution or any possibility?
My interaction with all the top people who take decision is, sir, I agree with you. It's a matter that award should be implemented immediately. But then I have somebody who will criticize me. There's a CBA, there's a CVC, then the courts are there to sit on my head and say, why did you do this? They impute all kinds of malpractice on my part. They impute corruption. So therefore, you say, I don't take a risk at all. I'll say, go fight. That the Supreme Court decided ultimately. That if there were now, of course, every government will now use curative petition also. Just watch. After Supreme Court, it would stop. Now they say, the man in charge will say, try curative petition also. Let's take a chance. They take a chance because they are using my taxpayers' money. That's what irritates me. I honestly pay the tax for this kind of litigation.
Right. Yeah.
Ridiculous.
So, sir, do we see...
Two parties, look, two commercial parties want to fight with their money. There is their lookout. You do what with them. But what are you doing? You are encouraging the government to go and charge something that should never be challenged by honest lawyer telling you don't do it. At whose cost? At Nidhi's cost, at my cost, at your cost. That is not fair.
But sir, we've been talking about this. Okay, Karthike needs to leave.
I need to drop off, Nidhi. Sorry.
Okay.
Lovely speaking with you all. Thank you so much.
Thank you.
Thanks. Bye.
Bye, Karthike. Carry on your good work in Singapore.
Thank you. I'll see you soon, sir. Thank you.
Okay.
Right. Thank you. So, but sir, we've been talking about this government litigation, government being one of the biggest litigator, and we don't seem to see any, I don't want to sound like a doomsday, but don't seem to see a way out of it, because that's why I see...
Nidhi, there is a reason for that.
Right,
how did we start? We started with the social justice pattern.
Right.
Remember, 50s to 70s, the judges were acting absolutely upholding all fundamental rights and setting aside all this legislation. 70 to 80, there was a transformation. Everything was tested on this concept of social justice. Directive principles were held paramount, fair enough. Then 90, there is liberalization. Right? Now, unfortunately, you already have a momentum and you are unable to control the new direction that you are asked to take. It will take time.
Yeah.
Then 90 to 2024 is not such a long distance. We are still in the previous momentum. But someday the momentum will come to a stop, and then you will say, this is the direction that I have to take, you have to take. Unless, of course, by that time the direction is completely reversed or changed or something happens.
Something happens.
Can I say something?
Yes, ma'am.
So I think one way, obviously, this is a problem which is there in litigation, which is there in arbitration. So one way can be that the government start applying its mind in trying to find out the most effective method of dispute resolution. Because what has happened is in the national litigation policy, they have made that all the government commercial disputes should go for arbitration. And in arbitration, there is a problem that the interest on the award is not at par with what is there in the civil litigation. So if that somebody can do that, to think whether they should go for arbitration or not also is going to be of some help.
Ruhi, what is the alternative? They'll have to go in for civil litigation. That will be interminable. It takes 25 years to decide one construction dispute.
There can be specialized dispute resolution process just for government disputes.
That is always a dangerous thing. Having special resolution by special judges is anathema to the general public.
Just to add on to what Ruhi is proposing, I think government, Ruhi, usually these departments have a specific committee, etc., for deciding it, comprising of their own ex-people, retired officers and all.
Yes.
But it has never borne no fruit has come out of those. It ultimately goes on to litigation or arbitration.
Governor, do you remember Supreme Court had passed a judgment and said, if there is an inter-dispute between two departments, it should never be brought to court. It should never be taken to litigation. It should be decided by a committee of secretaries of the various departments. Have you ever seen that happening in practice?
Sir,
May I? An option which is available to them. That's why they go for that option.
Sir, I will just give you one example from practical. I have been asked to assist one of my clients in a similar committee. That committee has been going on for 8 years. The quantum of the dispute between two government parties is 3.5 crore rupees. And for 8 years, every Saturday, they will all sit together in an auditorium, 25 officers with snacks and tea being laid down, and nothing is coming out of it. It ultimately has, I don't know what will happen to the arbitration ultimately, but this is what generally is happening. So thinking of an alternate resolution mechanism for government dispute, I think it's a little difficult to think of, I think.
You know, it would be interesting to see how we can introduce a mediation process by an independent professional mediator as a precursor to any arbitration.
It depends. The Act says that no, mandatory one.
The commercial
right now we have it says there should be a mandatory mediation as precursor. Now, who is
it would be
following
interesting
this?
To see how that plays out.
I don't have any data, but have you any idea of how many government mediations have taken place? I have absolutely no data. No, I am leaving it to you people. You people are in the field more than I am.
Yeah.
It's almost it's 2 years since the Act came into.
The percentage is 0. If matters have been sent to mediation, resolution is 0%. I can talk from my experience of at least doing.
Resolution is 0%. Governor, the resolution is 0% is the consequence. In how many cases has government as a litigant agreed to mediation?
I may have done 300 cases till now. Hardly 10 cases they have agreed for mediation.
Sir, in mediation, why they are not agreeing is because the reason which sir has given, that they will have to give answer as to why they are settling for whatever.
Therefore, ultimately, it's a question of trust. It's a question of passing the buck. The buck stops somewhere. Let it stop there. Why should I be bothered to hold the buck?
Yeah, so no one wants in one's own tenure.
No one wants, because, and we are also talking of government should do this. Government, what is the government to do this? Some officer has to decide. No, what is government? Government is not an amount for the body. It's some departmental issue. Say secretary has to take a call on that. If he can't take a call on that, he'll go to the minister. If the minister can't do it, he will sit in the PMO and decide it. That is where the buck stops. No.
So why can't
these things don't happen at the lower level?
No, why can't there be something like the procedure for Section 80, that now there is a nodal officer who will be personally liable. So some such kind of accountability. This is just thinking out of the box. It's kind of a thing which may happen in such cases as well.
Actually, I was sitting on that committee which was
I
decided
know,
talking
sir.
of amendment to international, what is that, treaties. And I had very strong criticism to the secretary who was present there. I told him, this is what you fellows are doing. Bilateral treaties, all bilateral treaties was, their success rate was almost zero. Therefore, they went and discontinued all the treaties, then brought in the model 1915
That
model, not
2014, sir.
1920, the model
Model BIT, yeah.
So at least the
Model
least the
BIT,
government can do is maybe when they enter into a contract, they should be slightly careful, because there was some problem in the L1 problem here, the contract and the tender which was floated. So that if that is taken care of to some extent, some disputes will be better handled. This problem was there in this case about tendering and division of responsibility between DMRC and the other party. So those things are also something which require diligence by the government officials.
But sir, yeah. And so Gohar, I would want to ask Gohar and Priyanka, both of you in that sense, because it's like there's not been too long that this judgment has come, but already in this short span, do you see that there's a surge of Section 34 petitions, or like you trying to use this judgment to challenge an award? So has this been a practical effect of this judgment, though it's a time span is very short? So
So I will give you my experience first. As recent as yesterday, I have one case, and I'm advising the client on a similar issue where, at a 37 stage, the award has not been set aside. The 34 single judge's order has been set aside, and the matter is remanded back because they have to reconsider the question of restitution of the amount that has been released under 34. It's a very complex situation, but I think it's the effect of DMRC.
Priyanka,
remand is a known power of the appellate court under the Civil Procedure Code. Now,
Absolutely, sir.
When is
Not
it
really
invested
34.
in the appeal under 37?
Absolutely.
The 37 appeal is exercise review of the exercise and the power under 34.
34.
It's not an independent appellate court.
I have a slightly different view from Gohar. I do not foresee this judgment opening the floodgates for Section 34 decision. Because
No,
Section 34 filing,
has
I mean,
nothing to do with
the
it.
curator, yeah, I mean, this decision has not created a new ground for which
34,
a
you're right.
34
There
can
you
be
may be right.
filed. What this can do is, generally after an SLP is disposed of, you try a
Then
review.
go for it. Exactly.
After review, you tell clients or litigants are aware that a curative is always, like Justice Srikrishna pointed out, a rarest of the rare case. For arbitration, there was only one, which was stamp duty, and that was really warranted. But now, perhaps this could open the floodgate for a curative to be filed against a Section 9, a Section 11, or maybe a Section 34 decision, which ultimately lies before the Supreme Court.
but do we see?
When the provision is there, that
Can we-
certificate
yeah.
of a senior counsel should be attached. You pay him 1 lakh, some fees of 1 lakh or something is fixed. You pay 1 lakh to anybody like me will say, oh, this is very good case for curative. Why sue the judgment in DMCR? Chalo, de diya.
So
But-
I think
It's going to happen. Just
what
what
may happen
you are
here
right.
is-
You are being absolutely predictive of the future. So this is going to give one more step in litigation for all unsuccessful litigants at the SLP stage.
maybe one thing which can happen is reappreciation of evidence, and the determination of the facts can also be something which may now be done under Section 37.
So why do we then waste time on this? Why not have a civil litigation where it will be
Civil
done purely appreciation
That
of
can be repercussion of this curative.
But I think
I
that
don't know.
yeah, but then can we say it again, like as Gohar was suggesting, that this court has done that, Supreme Court, 3 judges, like as in standout because it was going to have an impact on the population and all, that now we expect more restraint from the Supreme Court in entertaining curative petitions and treating this as a more like a standalone judgment and not to be treated as
Me, as a Supreme Court judgment, I used to hear at least get only 2 curative petitions in the week.
right. Okay.
I used to ask them a simple senior lawyers, who are paid, I don't know how many are there per appearance they are paid. Their bank balance was increasing day by day. I used to ask them 3 questions. Is it bias of the judge? Is it abuse of the process of law? Is it violation of natural justice? No, good luck to you, get out. That is the only scope left for him. And if he says, no, he did not consider X, Y evidence as against Y evidence, then there you have no point in asking it in an arbitration act.
So, sir, we expect that Supreme Court, after this judgment and after the kind of uproar and the criticism it has attracted, probably we expect more restraint.
It should. And that is why I said academics like you should write strong criticism.
Right. That it should not become.
I am a lone voice, nobody cares for me. If you write and say there is so and so professor of such, and then Professor Paul writes, there is something to be said. These ladies are saying something very interesting. Supreme Court should say, okay, we'll redress them. Maybe who knows, there may be 9 judges bench, which are not 9, sorry, there's only 5 only, no, 3 only. These were 3 only.
This has 3 only. This has 3 only.
Oh, very good. The 5 judges bench will sit together and say, no, this judgment is overruled. We go back to Ashok Rupa Hura versus.
Yeah, this was only 3 judges. Yeah, it should.
Speaking as an optimist as an optimist and a student of an arbitration, the judge does in fact say that a curative should not be exercised as an ordinary course, but in complete contradiction it did. So I am hoping that the trend of pro-arbitration cases, which the Supreme Court has set out in the last 2 years, will continue, and this would perhaps be an exception to that.
I think it's time we wind up. No, 5:15 tak na tha?
Yes, sir. Yeah.
I have one thing to tell all of you. I don't know how many of you have read Russell on arbitration. I'm sure all of you are clever people, you must have read. There is one statement he says, process of arbitration is like running a relay race. The party should know where the button should be at, in whose button it should be hand at one point. He says before the court started, it's in the hands of the parties. When the court is, the arbitration is invoked, it's in the hands of the judge. And thereafter it goes to the hands of the parties. Now if the judge says, beta hamara paas aaya, hum bhi karenge, kuch nahi karna hai tumko. And he insists on running because I am a champion racer. I can always come first. That is not arbitration, sir. That is all that I'm saying. Right. Maybe Lord Russell was wrong, I was also wrong.
Right. So yeah, so I think it causes some concern, but as Priyanka said in Gauhar, I think definitely would agree that we can still have an optimistic note.
Yeah, we are all optimists, correct. If I were not optimist, I wouldn't be living up to 83 years of age in this country, in this atmosphere.
Yeah, and of course, yeah, and till the situation changes or we keep optimism, and of course, I think one closing point for this could be, before we take, sir, if you permit, we just take a couple of questions if the participants have that.
Yeah, sorry, one more question. We got into all kinds of arguments.
Yeah. So we'll just see if the participants have it. And I think we can probably for the moment also kind of agree and pause or take it as that when, as far as it is that the government is a party in the contract, that will have to be treated, will continue to be treated differently, in a different plane. And another second point associated with this, since this was a domestic award, this was not an international commercial award. So, and in the international commercial award, we would not have a ground of patent illegality. So probably in that context also, we can have this optimism that this will not affect the awards arising out of India-seated international commercial.
Correct. You may be right.
So that's a ray of hope that,
but still this Ashok Hurra's thing will haunt people always. Ashok Hurra has been bypassed. They are not bypassing because it's a domestic arbitration.
Right.
They are bypassing from general observation, which is going to have effect to the next judge who has to decide a curative petition.
Right. So, sir, we just say that the participants have some questions. So, Anshpreet, if you, if one or two questions, probably, from the participants. Yeah. So, just one or two questions.
Okay.
Most of the questions.
Hard stop at 5:30.
Okay, definitely hard stop at 5.
Most of the questions have been addressed by the panelists. There is just one question which I think the panelists can take. So this was an arbitral tribunal consisting of 3 technical members. Would the award be different, or would the decision by the Supreme Court or the High Court be different if this tribunal consisted of both judicial as well as technical members, or the fact that 3 technical members were there impacted the review of the courts?
You are right. There could be 3 chief justices, former chief justices as arbitrators. I've seen that happening. Then I don't know. You may be right on that. I have no idea what it happened.
So, Gawar, Priyanka, what do you think? Do you think that
I think the question is of relevance, and it would have made a slight difference in appreciation or reappreciation. But I think it would have made some difference.
Yes, it would.
Because
have.
this also has a
normally you
bit-
expect a judge. You see, this is why, however much we may criticize, well, old fogey like me, we are judges who have done this exercise for donkey's number of years. So do you expect us at least natural justice will follow? And bias, if there is, we will disclose it, and so that section 16 comes into force. And what is the third one? Abuse the process. A judge is not prone to do abuse the process of law. Therefore, people think it's safer to have a judge. You can have an technical expert. In fact, I remember Russell also says it's always arbitration in commercial disputes is best resolved by the person in the industry. And he gives an example. If there is a situation of whether this wall has been built properly or not, it is the bricklayer who can give the best award.
right?
The judge of the Supreme Court will not know whether the brick is good or bad, how long the wall will stand. But the bricklayer can give you an answer. Similarly, if a question of a diamond being good or bad, it's only Gawar who can answer it. An ordinary person like me will not know what it is. I don't mean Gawar Mirza, I mean the Gawar in the diamond market. That's why it requires some expertise. But the only good thing that is a judge or a lawyer as arbitrator will make sure that the legal process is properly cut. And he can take recourse to experts, evidence, he can appoint assessors where technical issues are raised. That is the great advantage.
So, Priyanka,
I completely agree with
yeah,
Justice
sorry, yeah,
Srikrishna.
yeah.
I think dispensing justice is one, writing a judgment is another.
Yes,
And
correct.
it is a judgment that stands in scrutiny before a 34
Correct. Ultimately, it will be criticized. Correct.
And tomorrow, if we still have arbitrations where you have 3 members who are technical members, then maybe they can have a secretary, which is a lawyer, which can guide them in terms of the process. And see how they can have an award that will stand the test of 34.
Correct.
I think that brings us to the importance of institutional arbitration. So we have a proper tribunal secretaries who can assist technical members. So I think
that is the advantage of institutional arbitration, which is what we, in the 2015 report, we said from beginning to end. And after examining all that White case, Mary, what is that report?
Queen Mary, the Queen Mary International Arbitration.
The Queen Mary report also.
Right. Okay. So, Ansh, do we have one more question or do we close it here? Is there any other question?
There's
Okay.
one more question if the panelists have the time to address, or else we can close it.
Yeah, very quick, very, very quick. Yeah.
Right. So we can see that in section 37, currently there is a provision that allows the parties to approach the Supreme Court and thereafter leading to the curative petition. Do the panelists feel that there can be any change in the Arbitration Act which can prevent such recourse to the Supreme Court?
No.
Or once 136 is there,
This question is wrongly premised. Section 37 doesn't allow you to go to court.
Yeah.
It is the constitution which allows
the
you to go to court. You look at the constitution and how 136 is abused. If you had the original provision of 132, 133 and 134 certificate of appeal, 99.9% would be finished here in the High Court. Now we don't trust the High Court also. Obviously, we don't trust the district judge. We don't even trust the subordinate judges. The wisdom lies only in Delhi. That is the problem.
Okay.
I'm sorry, I'm saying this because this has come out of the experience that I've had in last, how many years, 64 years or whatever I'm doing this law for this.
Okay.
Sorry, just to add to that, I think it would be unfair for a litigant to not have the option to go to a Supreme Court because it chose an arbitration over a civil suit before a district court.
Right. Yeah. Okay. So preventing it for probably 150. So I think we can conclude with this, and probably you can.
This brings us to the end of the webinar. Justice B.N. Krishna Sir, Professor Dr. Ruhi Paul, Mr. Gawar Mirza, Ms. Priyanka Shetty, Nidhi ma'am, and Karthike, who couldn't join us till the end. On behalf of the Center for Alternative Dispute Resolution, NLU Delhi, we are extremely thankful for your presence for this webinar. Your contribution for this webinar has been immense. We have been able to understand concepts related to jurisdiction of the Supreme Court, the impact of this judgment on arbitration and the future of arbitration in India, the enforcement proceedings in India, as well as the questions of ease of doing in business. We have also been able to address the question of what can happen with state-owned entities and whether there can be a different dispute resolution mechanism for entities involving states. So therefore, I am pretty sure that all the participants, we had around 200 participants, more than 200 participants who were able to hear from you. So again,
Yeah.
once more, thanks
Yeah.
a lot for your guidance. And we hope to have further collaboration with each one of you. And that is it from my side. Thanks a lot on behalf of the Center for Alternative Dispute Resolution.
Thank you.
So
Yes, ma'am.
I would
I
also
have a
like to
question.
thank on behalf of the National Law University and the Center for ADR. I am extremely thankful to all the panelists, especially Justice Srikrishna ji, for giving us time for this webinar, and also for the participants without which this webinar would have been of no consequence. So we have an overwhelming response, and we have 200 plus participants attending this webinar. So thank you so much to all the participants also, and the panelists, and Dr. Nidhi especially, for moderating this webinar.
Sir, you wanted
No,
to
I
say
have
something?
one last suggestion, that you have excellent people like Nidhi, Ruhi Paul, Priyanka Shetty. You have access to all kinds of academic journals. Why don't you write in that and say the Supreme Court is wrong or right? Well, if you want to say it's right, you are welcome to say that it's right. But please put it in the form of a scholarly, peer-reviewed journal article.
That's true.
Then
Yeah.
there will be
Yes.
some kind of weightage given to you.
True.
Otherwise, this
true.
kind of seminar, nobody bothers.
So we will do.
Yes.
Please do it. You people, you have a journal, isn't it, published regularly?
Yeah, we have one.
You can write your own journal, or you can write in any of the peer-reviewed journals, academic journals. That will carry weight not only in India, but all over the world.
All over the world. True, sir. Yeah, that's
Yes.
something which we are seriously lacking. Yeah.
You should do it.
Yeah.
You will seriously lack that. No legal, I have not seen any scholarly legal article in India, whereas in England, they refers to the journal articles in England and in Supreme Court. I don't
True.
think our Supreme Court refer to any.
Doing that. Okay. Great.
The only
So
thing
thank
that
you,
I know
sir.
is that-
Sorry,
Thank
sir. You were saying something.
I said the only time I saw it was when they referred to, what is his name, Professor
Upendra
in,
Bakshi.
Upendra Bakshi. That was
Right.
in that long judgment about
Long ago. Yeah. True. Yeah. Great. Okay. So thanks
Professor-
once again. Thank you, sir. Thanks for joining. And we'll
Thank
keep
you.
bothering you again and again as whenever I'm able to chase you. So
as of day after tomorrow, I will be away for 4 months, 2
Yes,
months in London, 2 months in somewhere in America. If you can chase me and catch me, I'll be happy to sit and talk
sure.
to you.
Okay, great. Thank you. Thanks,
Thank you.
Gaur. Thanks, Priyanka. Thanks.
Yeah, all the best. Thank you very much. Thank
Thank
you
you,
all,
sir.
Gaur,
Thank you so much.
Maruhi, Bhaiya Priyanka, Anshpreet, Tarun Dayal, and all the other participants here who are listening to it without showing their faces. Thank you very much. May each of you debate it. Don't take it just because I'm saying or Nidhi is saying or the Supreme Court is saying. Think, and then come to a conclusion.
Right.
That's
Great.
Sorry for interruption, but can I ask a question? Even though the panel is like dispersing.
No,
I
you
just
don't want to think.
No, I want to think, but still I wanted to ask the question. Even when the arbitration seat or arbitration are outside India,
Yes.
but the assets are in India, then whether the party choosing outside India would have any impact as the award can still be challenged in High Court.
No, you see, the point is, if you choose an arbitration seat outside India, the one advantage is there is less interference by judiciary in that, unless there are extraordinary circumstances. Then you get an award, again you come back to India to execute it, and the execution machinery in India is hopeless, to say the least. Anybody who has done civil procedure code and Order 21 and all that will know what kind of a machinery we have. Well, if you are lucky, you'll get with it. Otherwise, second generation, third generation will see the assets. See, therefore, there should be a parallel machinery. Like, for example, take what happens if it's the government debt, you are a debt relief tribunal or something. And if you have a government debt, where you take money from, what is the state, SIDC or whatever that Industrial Development Corporation,
Exit.
they have an extraordinary right to take away your money. You default on Income Tax Act, nothing to do, they'll come and swoop on you like vehicles. When it's government, it is there. When it's a party, go stand in the court and wait till the court has time to look at you. This is the problem.
Right.
That is why the government made special machinery for itself. Now, maybe justified because government is dealing with public money. Maybe unjustified because government is unnecessarily spending public money.
Both ways, yeah.
Right. Thank you very much.
Thank you, sir.
God-
Thanks a
Thank you
lot.
so
God
much.
bless you all. May you
Thanks a lot
continue
to all
to.
the
Thank
panelists.
you, everyone.
Thanks, Priyanka.
Thank you.
Thanks, sir. Yeah.
Thank you,
Okay.
everyone. Bye-bye.
Bye.